Let me mention item number 13.
Item number 13.
Comma observation.
On the request of Ms. S. B. Chaudhary, learned counsel for the petitioner, this matter stands adjourned for 3 weeks, list after the ensuing summer vacation.
My lord, I beg to mention item 12. We have received our instruction. We would like to file our affidavit.
I am for the petition.
No objection.
I have having an interim protection.
All right. Mr. I. Bothakul, learned standing counsel, Forest Department, Assam, appearing for the respondent, submits that he has received instructions and therefore be granted how much time?
After vacation, my lord.
2 weeks' time to place the same on record in the form of an affidavit. Since the prayer is not opposed by Mr. Banik, learned counsel for the paid petitioner, same stands allowed. List this case again after the ensuing summer vacation. Interim order passed earlier to continue.
My pleasure.
There is some interim order here.
There is.
Yes.
The court, matter item number 39 of court number 10 was listed today,
Hmm.
but that the court has been deferred. That is why I have mentioned it if it is possible.
What is the matter about?
Whether it is a pension matter.
If it is a case which cannot wait till tomorrow, I'll take up. Otherwise, nothing. Can it wait till tomorrow or day after?
Day after tomorrow, maybe.
Day after tomorrow.
If is a lawsuit. But if I paid for listing of this petition lawsuit, we have filed on 10/6, but it is not listed. And then the Wednesday, can it be listed in lawsuit?
For motion,
Lawsuit.
Wednesday? Yes.
My pleasure. My lord, these two contempt matters, my lord, order dated 21/5/2, my lord, list after 2 weeks, my lord.
Mhm.
This is the 4th week, it's not being listed, my lord. My prayer may be taken up, my lord.
What is wrong with the system we have set up? Any complaint about it?
All right, all right.
No, there is a listing system here.
Yes.
Why are you challenging it?
In fact, my lord, 2 weeks already expires, my lord.
Why are you challenging that listing system where councils can just enter the number of the case and it is listed? Is it because of your ignorance or something wrong with the system?
In fact, it's all right. But
Then
some urgency in my part, my lord, because that's why I'm praying before your lordship.
have you entered the number in the register?
Not my lord.
Do you know that there is a register there? You don't know.
Yes, yes, ma'am.
You don't know.
Yes, yes,
Say that.
yes,
I thought there is something wrong in the system. Everybody is getting relief.
yes.
Follow the system.
If you
Yes.
May please, Lordship. Lordship, this matter pertains to court number 10, my lord. It's an arbitration petition, my lord. Our station councils are appearing, my lord. It is filed on 12. May I put it listing on 18th, my lord?
You want item number?
No, not item number, listing for first time, my lord. Our station council are appearing on 18th, my lord, if possible, my lord.
But the learned judge is not available, right?
What would they?
But this matter will go to that court only
Yes,
because it is a,
yes.
give the mention memo.
My pleasure, Lordship. Lordship, I am appearing on behalf of Mr. Irofik, Lordship. I beg to mention for item 7, Lordship, kindly pass over the matter for the day, Lord.
What do you want? Item 7?
For pass over for the day, Lordship, as Mr. Irofik is out of station.
On the prayer of learned counsel for the writ petitioner, this matter stands passed over for the day. List accordingly. Yes.
Right, please, your lordship. Lordship, I beg to mention item number 14, lordship. Today some difficulties, lordship. Kindly adjourn the matter for 1 week.
1-4.
Yes, lordship.
You want adjournment for how many days?
For 1 week.
On the prayer of learned counsel appearing on behalf of the petitioner, this matter stands adjourned for a week.
Oh, please, lordship.
Please, your lordship. Your lordship, I'm mentioning the item number 29 for that is fixed in court number 10. There is an interim order that was still effective today. We're praying for the interim order to be continued.
Item number?
29.
You are for the petitioner.
Yes, your lordship.
That is 29 of the other.
Yes,
court.
your court room number 10.
Likho soon, item 29. Your name, please?
K. Bhattacharya, your lord.
Ms. K. Bhattacharya, learned counsel appearing for the writ
A
petitioner.
date may be fixed, your lordship.
Submit. You want extension of interim order and date both?
Yes.
Choose one.
Yes, the interim order.
Submit that the interim order operating in this case is valid only till today, since the concerned bench is not sitting. Hence, the interim order be extended and the matter be posted after the summer vacation.
Yes, sir.
Prayer is allowed. Register to list this case again immediately on reopening of the summer vacation. Interim order, if any, passed in this case shall stand extended till the next date.
Your pleasure. Any list for motion item 1.
May I please your lordship?
Yes,
Also, on 30/5/2024 earlier, my lord, may peruse the order dated 30/5/2024, my lord. My lord, respondent was supposed to file affidavit, my lord. Here, my lord. Matter pertains to my lord selection and appointment for the post of junior engineer, my lord, in the PWD department.
so what has happened? Selection process has not been.
Selection process over, already appointment were in 2024. My lord, even case notice was not been issued, my lord. That's why we are not going to file in the Philippines, my lord. It was still in some stage, my lord.
Selection is over long time back, 2022.
Yes. But on that 30/5/2024 instruction was supposed.
That's his instruction, so we'll dismiss it, or you withdraw and file afresh by incorporating. You can't challenge the selection process because there
Already
is no
appointment
pleading
was
here.
from
Withdraw, my lord.
Huh?
Withdraw, my lord.
Then you withdraw it, otherwise the court will have to pass an order of dismissal. Appointments, actually you take down. Heard, Mr.
A Gayan, my lord.
A. Gayan, Land Council appearing for the petitioner who submits that instructions as directed by the order dated 35/2024 have still not been obtained by the respondent's counsel. Stop. Today when the matter is called up, Mr. T.J. Mohantal and his senior counsel assisted by Ms. P. Sharma, learned counsel for the APSC, submits that the selection process in question was initiated in the year 2022 and the same has not only been concluded long back, but the process of making appointment of the selected candidates are also over. Under such circumstances, nothing survives in this writ petition at this stage. Responding to the said submission, Mr. Gayan seeks leave of this court to withdraw the writ petition with liberty to avail appropriate legal remedy as may be available to his client. Prayer is allowed, writ petition stands disposed of with liberty as paid for. You are also appearing? Mr. S. Bhuyal and counsel is present for?
7 and 8.
Respondent numbers 7 and 8. Anybody else appearing in this case? APSC to Harry Kojibor. APSC respondent number 4, 5 and 6 to 7 and 8 are Miss A. Talukdar 1, 2 and 3 Kojibor. SBI is for 9. You're for 7 and 8. 8 and 9 Kojibor. 8 and 9. No? Yes. Disposal. What is the IA about?
My lord, I was already not pressed, my lord. It was disposed of. Much obliged.
Item T.
A similar matter has been tagged with the review.
On the prayer of Mr. S.K. Royal and counsel for the petitioner, list this case along with review petition number so-and-so, which is stated to be pending before this court. And who are appearing for respond numbers? Serially give the names. Miss A. Talukdar, Lanet G. Assam has appeared for respond number
1 and 2.
1 and 2. Then who is next?
3.
This R. Deka, RM Deka for respond number 3.
Lordship, I am for 4, 7 and 8 in all the matters.
Mr. Dupamenu for respond numbers 4, 7 and 8. Who is for 5?
Lordship, I am appearing.
Mr. B. Chaudhary, Learned Counsel for respond number 5. And Miss S. H. Tarang, Learned Counsel for respond number 6 are present on behalf of the respective respondents. Full stop. Office to list the matter accordingly. Hmm?
3, 4, 5.
3, 4, 5, 6, same.
Same.
And parties are also same.
Same.
All right.
3, 4, 5, not 6.
3, 4, 5.
Sorry. 2, 3, 5.
2, 3, and 4.
2, 3, and
2, 3, and 4, yes. 2, 3, and 4 एक कोई नहीं.
Wait, please, your lordship. My lord, I want to highlight only one point, my lord. My lord, I was appointed as the, my lord, works as Khalasi, my lord, in the year 1982, my lord, at page 39, my lord, your lordship, kindly peruse page 39, my lord. Along with, my lord, serial number 1 is Sadhan Ujai, the petitioner, and serial number 4 is one Bijon Hafila, my lord. And it, my lord, it was upgraded to the post of works as a plumber, my lord. Thereafter, at our, my lord, the post was, my lord, regularized at page 53, my lord, your lordship.
So is this case covered under the judgment?
My lord, in the observation, the observation is that
You file your affidavit.
yes, my
Have you got your instruction?
yes, the instruction is that, my lord, in page number 67, my lord,
Hmm.
my lord's observation says qua the petitioner, my
Yes,
lord.
and a similar
And
person.
that is why, my lord, this
So
petition-
then let him file the affidavit. We have to pass a final order. It cannot be done without notice.
Yes.
I heard Mr. N. Circle and counsel for the writ petitioner peruse the order dated 28/5, 28 pass, 2025, passed by this court, granting time to the learned departmental counsel to obtain instruction. Mr. I. Botaku, learned standing counsel, PhD department, Assam, appears and submits that some instructions have been received and therefore, you are appearing, Mr. Nayak?
Yes, for finance department.
এটা উপর টার নামটা দিব মিস্টার পি নায়ক and additional AG bracket finance bracket plus Assam as appear and submits that some instructions have been received. You file an affidavit.
Yes, lordship, I have to file my affidavit.
And therefore some time be granted to obtain to file an affidavit. Prayer is allowed. Issue notice of motion returnable on 21st of July. 21st of July. Since who is appearing for whom?
My lord, I appear for 1, 2, and 3.
Since Mr. I. Botaku, learned SC PhD, has appeared and accepted notice for respondent numbers 1, 2, and 3. Miss R.M. Decker, learned standing counsel, you are Dima Hasau, standing counsel Dima Hasau, for respondent number 4. Who is for 5? PhD?
5 is an authority under council, man.
Achha. You are for 5 also? 4 and 5. But then 4, 5, 6. Yes, Mr. P. Nayak, additional AG,
For
bracket
7.
finance, bracket close, government of Assam for respondent number 7.
Yes.
Mr. S.K. Medhi, learned standing counsel for the office of AG A&E Assam for respondent number 8. You are for 9 also, Ms. Deka? Ms. A. Talukdar, learned G. Assam for respondent numbers 9 and 10. Service of notice is deemed to be complete in this case. Extra copy of the writ petition requisite in numbers be furnished to the learned department counsel so as to enable them to obtain instruction. District of.
Okay.
Item 6.
May it please your lordship. The lordship, in this matter, I am challenging an advertisement issued by the.
Similar matters are pending.
Yes, my lord.
Show the order.
Order copy I presently do not have. I do have the number of the writ petition, your lordship. 1665 of 2025.
Then we'll have it next week. I have to take out the order then. What order has been passed?
Lordship, pass over the matter. I will collect the order copy.
Lordship, in this case, my lord, respondent number 4 filed affidavit. So I need some time to reply and notice also may be issued.
Heard Mr. M.R. Khondakar, learned counsel for the petitioner, peruse the statements made in the writ petition the petitioner herein, who is a ASHA worker, ASHA worker, is aggrieved due to non-payment of her current remuneration as well as arrear salary, full stop. Mr. Khondakar submits that the respondent number 4 has filed an affidavit and therefore he be given some time to file rejoinder, full stop. Prayer allowed, issue notice of motion returnable in 4 weeks. Since who's for Miss A. Boral, understanding counsel, Health Department, Assam has appeared for respondent numbers 1, 3, 4,
Debor.
1, 3 and why not 4? Joint Director Health Service. Any problem with him? Then and what about 6? You have for 6. It 1, 3, 4 and 5 and Miss A. Bora, Learned Standing Council, NHM for respondent numbers 2 and 6.
Yes.
Service of notice is deemed to be complete in this case. Extra copy of the rectification requisited number to furnish to the Learned Department Council so as to enable him to obtain instruction. Enable them to obtain instruction.
But here the petitioner and his spouse both serve at Guwahati, and they have a child who is disabled, certified disabled with autism. When both made applications for spouse posting to a place where they can take care of their child since their transfers were coming up, the wife's application was accepted for a choice posting at Chandigarh or wherever the linguistic development can be there. The husband's the representation was rejected, saying that only there was no finding that both the parents would be required. In such view, they were required to take instructions. They filed their affidavit. We have filed their affidavit in the reply, showing that both the parents would not be required. The doctors have certified that both the parents are to be there for the at least next 3 years, till which time the child can be given treatment for rehabilitation. Beyond that, it would not be any cure for him. It would only be a taking care. It is at that stage that this matter has now come up. The husband is under interim protection. The Lordship has the transfer order.
So right now, both the parents are posted where?
At Guwahati. At Guwahati, but the wife's application to be transferred, if necessary, to a place where the child can have the linguistic problem solved. That is Chandigarh and other places, was accepted. The husband's was refused.
So what is the consequence? Husband will now be in Guwahati.
He was posted to Jaipur.
Jaisalmer.
Jaisalmer, I'm sorry. So now when both are now with the stay order, they are now both at Guwahati.
And
the wife is not before
what post they are holding?
both one is a major.
One is a major.
Major and the other one is also
Other one, Lieutenant.
Lieutenant Colonel.
Now, Lordship, I have taken the instructions on the basis of the views expressed by this Honorable Court on the last occasion. Now, Lordship, as per the medical board, there is no necessity of both the parents being there at the same place. However, Lordship, there would be no difficulty if the wife would like to be here for the time being. But the husband has to move. Lordship.
Well, then we have to decide. Then we have to decide. There will be some delay. We'll issue notice and decide it. Because ultimately the court may decide that you are bound to post them together. Then
that of course, Lordship has to make some determination.
But if on the fact situation, if you could find a way out, then it would not have been necessary for the court to go so deep into the matter.
I do understand, Lordship.
Otherwise, you can't just say that, sorry, you may have a case, but we will not grant you relief. We can't say that. Is it
That
not?
is-
You can say that. You means your client, but we can't say that.
It's based on the medical boards.
And that's right. So,
The Lordship has to take a call on that.
correct. So then what option is left? We'll issue notice and fix it for admission hearing.
If it can be on an early date, Lordship,
You suggest a date.
immediately after the vacation, Lordship.
Do you have a preferred date? Okay,
Because next week it will be a motion day, it will be difficult.
correct. No, then the court has to pass a judgment. Let's put it that way. There's no option.
Yes,
A
Lordship.
judgment has to now come. Saying either one of the parents or both the parents. That is not possible unless the matter is heard. Heard Mr. R. Majumdar, learned counsel for the petitioner. Also heard Mr. R. K. D. Chaudhary, learned DSGA, appearing for the respondents who submits that an affidavit that submits that pleadings have already been exchanged in this case. As per the instructions received by him, one of the parents can be permitted to stay with the child either in Guwahati or in
The
Chandigarh
mother.
or in some other place. But according to the medical report, there is no necessity for both the parents to be together to take care of the child. The aforesaid aspect of the matter calls for adjudication, which would not be possible without some length of hearing in the matter. As such, issue notice of motion returnable on 22nd of July, 22/7/2025. Since the respondents are already represented by the learned DSJ, no further notice is required to be sent in this case. Considering the urgency expressed in the matter, an attempt will be made to dispose of the writ petition at this stage of admission hearing. Parties to come prepared accordingly. Interim order passed earlier to continue till the next date.
Can you just make one point? Since the wife's application was accepted, in case they do consider it, they can consider it along with the husband. This will not
It
be
is
a bar.
however made clear that pendency of this writ petition shall not create a bar for the authorities to redress the grievance of the petitioners in accordance with law and on mutually agreed terms, if so advised.
Deeply obliged.
Yes.
Lordship, petitioner applied for compassionate appointment, Lordship. His father died in 8/9/2008, Lordship. His elder brother, Lordship, first applied for compassionate appointment, Lordship, which has been forwarded, Lordship, in page number 19, Lordship. But after that, Lordship, no action has been taken. Then petitioner applied freshly, Lordship, and page number 38, Lordship, DLC held, Lordship, but
Petitioner's father died when? Which year?
8, Lordship.
2008.
8/9/2008, Lordship.
Okay, so that is about 17 years back.
Lordship.
All right. Now, you want a direction to be issued to consider the case.
Lord.
Achha, but what about the OM 18/9/2024?
Lordship.
Are you aware of that? Are you aware of the OM?
Last OM, Lordship, 224 OM, Lordship.
Yes, yes, 18/9/2024.
Lordship, that has been, Lordship, challenge, Lordship, and in coordinate bench, Lordship, that has been set aside, Lordship.
It has been set aside. Give me the order. I'll allow it right now. Which paragraph set aside? Just mark it. You take 5 minutes time. But you will need more than that. Where it has been set aside, you show me. Just wait for 5 minutes. Huh?
In similar case, Lordship, that
Set aside, show me that word, set aside.
Lordship, not wholly set aside, Lordship, but for that cases, Lordship, then when Lordship, may I pay, Lordship, to pass a similar order, Lordship, in that cases.
How can it be? You have not challenged the notification.
Lordship, challenge, Lordship.
Huh? And when have you
that-
filed this writ petition?
Uh,
After the judgment of
before,
court.
Lordship,
Huh?
Lordship.
No, Lordship.
Let me see.
File, Lordship, before the particular order.
You tell me, when did you file this writ petition? Give me the. When did you file the writ petition?
Lordship.
Date of filing?
Lordship, 29/3, Lordship.
29/3. And you have not challenged the OM dated 18/9.
Lordship, in later on challenge, Lordship.
Huh? Where?
Later on challenge, Lordship, by filing an IL.
Filing an IA.
Lordship.
Where is the IA? It is not listed. Can you give me the IA number?
Lordship,
210925.
2109 of 2025. Okay, then
Let
let the IA be listed along with the IA. IA has not been listed today. I heard Mr. A. Sharma, and counsel for the petitioner, who submits that an interlocutory application being IA number 2109 of 2025 connected with this writ petition is required to be taken up together, and therefore the matters be listed together. Ms. A. Talukdar and G. Assam is present on behalf of the state. On the request of Mr. Sharma, let this writ petition be listed along with IA number so and so in the next week for motion.
Can you see the last one?
Lordships, instruction awaited, Lordship, some more time required.
How much more time?
Yes, Lordship, by telephonic instruction, I have received that our process is under process. The procedure is going on.
Procedure for
how-
what?
He was qualified.
Tell these people to be a little careful. Right? Gee, the railway platform also so large. Why is he making so much noise?
After the physical standard test, CRPF declared qualified petitioner.
So
And
petitioner is
after
declared as qualified.
qualified, but
Now you have to appoint her.
yes, Lordship, that process is going on. How many time required, it is not, I have received, that instruction I have not received. How many time will be required?
Okay, then we'll record your submission and give you 2 weeks.
Please.
Thanks.
Heard
On last
Mr.
occasion,
H.R.M.L. and counsel for the writ petitioner. There is the order dated 26/5/2025, by means of which this court had granted time, 2 weeks time to the Lanes CGC to obtain instruction. Today, when the matter is called up, Ms. S. Borua, Lanes CGC submits that after the petitioner was found to be duly qualified and selected, the authorities now,
The final result not declared. He was qualified on his leg height. That is
qualified.
Qualified.
The authorities now are now processing her candidature, which would require another 3 weeks' time to finalize. As such, Ms. Barua has paid for posting the writ petition for motion again after 3 weeks. Prayer is allowed, list the matter accordingly.
May I please your lordship?
Yes.
May I please? Lordship, in this matter, inquiry was in favor of the petition, but it was deferred by the disciplinary authority without giving him the reasonable opportunity of being personally heard, my lord. That is the case. Inquiry report your lordship will find at page 44, operative portion, page 52. Page 52, your lordship. The last para, in view of the above, it is concluded that prosecution is not able to establish the sexual harassment charge against the officer. So that inquiry report so far, that was deferred by the disciplinary authority. Lordship will find at page 54, Annexure D. The last para.
So any CGC appearing in this case?
Yes, CGC. And Lords.
Do you have a copy of this?
We can start.
All right. The name is not shown. Let it come up with the name of the CGC being shown in the cause list.
No, this is the second. And last time what happened, my lord, my name is also not reflected in the
Correct,
cause list.
correct.
Because of that, that was missed last time.
The mistakes do happen. So you wait, let it. Heard Mr. D. Boral and counsel for the petitioner. However, none has appeared for the respondents. It appears that the name of the Lanes CGC is not shown in the cause list. Registry to therefore take note of the same and list the matter again for motion by reflecting the name of Lanes CGC in the cause
And
list.
my name may be.
Name of the Lanes counsel for the petitioner. Your name is now there.
Lordship, if it is first, then name will not be shown because
our names on only after notice issued and we file our memorandum of appearance, Lordship.
And
So if no order has been
Lordship,
passed and memorandum of appearance has not been filed, then name will not,
Your-
only DY as DSGY will be reflected
And
in that
Lordship,
case.
if the notice is issued, it will go to the council of the airport authority.
Let the name be, somebody's name has to be shown because union is a party.
Yes, my lord.
You come and make that submission, we'll pass an order that no need to serve any copy on the CGC.
No.
Then they will not serve.
No, it has to be served in the office. If they have
Then, if it is served, then somebody has to appear. Why will they serve copy otherwise?
After serving on the is fine.
All right. Petitioners Council as well as the learned CGC, the DSGY.
Yes.
Item 16.
Lordship, matter may be password for finding. Mr. M.A. is on lake.
What is this matter about?
Brief is not with me.
Huh?
Brief is not with me. M.A.
Alright.
Hussain is on lake. After some time.
You.
Notice issue করে দিলো,
So, by notice issue. Have you received a copy of the petition?
Lordship.
Hmm. What do you have to say?
Lordship, let notice go, Lordship.
You issue notice. Who is your senior?
Mr. M.A. Hussain.
You tell him that I am issuing notice. Heard Mr. M.A.I. Hussain, learned counsel for the writ petitioner. There was the statements made in the petition. The claim of the petitioner in this case is for release of arrear pension and other pensionary benefits payable on account of her deceased husband who was a government employee. Full stop. Government employee under the Department of Water Irrigation. Under the Irrigation Department of Government of Assam. Mr. N. Upadhyay, learned standing counsel Irrigation Department, prays for some time to seek instruction. NOM 6 weeks since Mr. Party Nambilak Didivo, since Mr. Upadhyay, learned standing counsel Irrigation
I am
Department.
appearing for 1, 3, 4 and 5, Lordship.
Has appeared and accepted notice for respondent numbers 1, 3, 4 and 5. Mr. R. Boro, learned standing counsel AG/A&E for respondent number 2 and Miss A. Talukdar, learned GA Assam for respondent number 6. Service of notice upon respondent numbers 1 to 6 is deemed to be complete in this case. Extra copies of the writ petition, requisite in numbers, be furnished to the learned standing counsel so as to enable them to obtain instruction. Petitioner to take steps for service of notice upon respondent number 9 by registered
7.
post. 7 by registered post.
Obliged.
The petitioner here is serving as an assistant sub-inspector in the CRPF and his claim is to the house rent allowance available at the last place of posting because he had to leave his family there. At this stage, my lord, perhaps a notice as to why I am not receiving the HRA.
Heard Mr. R. Majumdar, learned counsel for the writ petitioner. The petitioner here is presently serving as assistant sub-inspector in the Central Reserve Police Force (CRPF) and is posted presently serving as so-and-so and is presently posted in the 136 Battalion CRPF, at Nalbari, in which post he had joined on 28/10/2021. By filing this writ petition, the petitioner is praying for issuance of a direction upon the respondents to allow his claim of house rent allowance (HRA) for the rented accommodation maintained by him in Gwalior city for his family. First up, Miss B. Sharma, learned CGC, appearing for the respondents, has prayed for some time to obtain instruction in the matter. NOM 6 weeks. Since Ms. Sharma has accepted notice for all the respondents, no formal notice is required to be sent in this case. Extra copies of the writ petition requisite in numbers be furnished to the learned departmental counsel so as to enable them to obtain instruction.
Publish.
This Sumitra says only urgent matters are to be taken, others are deferred. Yes.
So this is the case of suspension without review. It's continued from September 2020.
Last time I was directed to take instruction, Lordship, instruction not received, Lordship. I'm
Then
paying
we'll
for-
allow the petition.
Judge, what for this case, Supreme Court it covered this.
Because
Another 1 week time limit, granted,
Huh?
Another 1 week time limit.
why instruction? From whom have you called for instruction?
This is from Principal Secretary Revenue and Disaster Management Department.
Why the instruction is not available? This
I have written. but
almost 10 days since the court had passed an order.
Lordship.
You give the name, we'll give him personal appearance. Let the officer come.
Next day, Lordship,
Huh?
one opportunity will be granted, Lordship.
Yes, tomorrow.
Tomorrow, day after tomorrow, Lordship.
Otherwise, you give the name, we'll call him for personal
Day
appearance.
after tomorrow.
Day after tomorrow. Heard Mr. H. Raman, senior counsel.
Ajay Kumar Chaudhary always settled law. Ajay Kumar Chaudhary Supreme Court
That's right.
settled law.
And also give the name of the officer. Who is it? The deputy commissioner? District commissioner?
Suspension order was issued by
Huh.
Lordship. Principal Secretary, in the name of Principal Secretary, Revenue and Disaster Management.
Then let him come to the court if he's not giving instruction.
Then next, if on the next that is,
On the request of Mr. S. Datta, Learned Standing Counsel for the Revenue Department, this matter is directed to be posted again on day after tomorrow, date to the for motion, so as to give him one last opportunity to seek instruction as per the order dated 6/6/2025 passed by this court. And please give his full name designation. We'll call him in the court.
Okay.
May I please, Your Lordship?
Yes.
Your Lordship, in this case, that there was some mistake while this annexures has been annexed with the writ petition. That is page number 193. It could have been the award copy of the labor court, but there is an evidence mistakenly. So I may be allowed to carry out the corrections.
You want to correct it?
Yes, Your Lordship.
What do you want to do? You want to withdraw or correct it?
No, I just changed the annexures, Your Lordship.
All right.
One annexure is-
Mr. M. Sharma, Learned Counsel for the petitioner submits that some error has occurred in annexing the documents to the writ petition in the correct chronology, and therefore he be granted leave to rectify the same. Prayer is allowed, however, any rectification in the annexures be carried out only in accordance with the rules and under the supervision of the registry. Once the process is completed, let the matter be listed again for motion.
And you're right.
Yes.
May it please your lordship. I have been dismissed from service on account of my conviction in connection with criminal proceedings. But while dismissing me from the service, the mandatory requirement under Regulation 40 of Assam Gramin Vikas Bank Staff Service Regulation has not been complied with. That is my grievances. And second, even in case of dismissal also, I am entitled for gratuity under the Staff Service Regulation. And also I am entitled for proof saving insurance scheme amount, etc. So
Yes. What do you say, Mr. Ganguly?
Because I'll have to file affidavit in this matter. Because he was convicted by two courts, trial court and the sessions court, and his revision petition is pending in this court, and the sentence only has been stayed. That
So his dismissal is due to conviction.
the conviction.
We'll issue notice that.
yes,
You are Mr.
R.K. Sharma.
Heard Mr. R.K. Sharma, Learned Counsel appearing for the writ petitioner. Also heard Mr. A. Ganguly, Learned Standing Counsel, Assam Gramin Vikas Bank Limited, appearing for the respondents. Full stop. The writ petitioner herein is a former employee of the AGVB. Limited na lage, AGVB. Due to his conviction in connection with as many as 2 criminal proceedings. A disciplinary action was initiated against the petitioner, and by the order dated 17/8/2018, he was dismissed from service. Full stop. According to the petitioner, the order of dismissal is illegal. That apart, even if the order is sustained, even in that case, the petitioner would be entitled to certain retirement benefits, such as gratuity, group saving linked insurance dues, etc., which has been denied to him for no valid reason. Hence this writ petition. Mr. Ganguly seeks 4 weeks time to obtain instruction and file an affidavit in this case. Prayer allowed. NOM 4 weeks. Since Mr. Ganguly has accepted notice for all the respondents, no formal notice. Extra copy of the writ petition requisite in numbers be furnished to the learned standing council so as to enable him to obtain instruction.
There is a prayer for interim also.
Heard on the prayer of interim relief, the said prayer will be considered on the returnable date. The learned standing council for the bank to come prepared with necessary instructions. We'll consider it on the returnable date. There were 2 criminal proceedings.
No,
is it?
look, the proceeding is one.
Well,
First,
proceeding is
he
one.
was convicted by the learned trial court, then his conviction was upheld. in the appeal.
Conviction in connection with criminal proceeding, not 2. Yes.
Well, it's a classic case where the authorities are trying to overreach the directions of the honorable court. A direction was issued to promote me from the year 2014 to the post of associate professor oncology. Now, what they did, my lord, after submission of the lawsuit order, they first transferred me outside the cadre. I approached this honorable court, transfer order state. Now they have issued an impugned charge sheet on non-existing government. So on the last occasion, Lordship directed me to produce some authority to show that at the defense of charge sheet stage, where the court can interfere or pass an interim order with the charge sheet. I brought one judgment directly on this point, my lord.
Judgment of which court?
Supreme Court.
Show me the law. What is the logic given?
Yes.
Because Supreme Court has powers under 142.
True, my lord. No.
That if it is a order under 142.
Under similar circumstances. The Chief Secretary of Punjab, my lord, what happened? He issued 2 notifications against these officials. Pursuant to that, the government changed, and against the Chief Secretary, a charge sheet was filed, issued, saying that you manipulated with record and all other allegations. He approached the Central Administrative Tribunal. Central Administrative Tribunal, by applying the ratio that no, at this stage we will not interfere with the charge sheet because you will get a chance to reply and rebut the allegation. Dismiss the OA. And against that OA, the Chief Secretary went to the High Court. High Court passed the charge sheet. State went on appeal to the Supreme Court. Supreme Court has upheld the High Court's order.
What is the law?
Yes, let's read them. My lord, it's 2001 2 SCC 330. State of Punjab versus V.K. Khanna. He was the Chief Secretary, my lord. But you will kindly then turn to para 33 at page 353. The law has been laid down here, my lord. Para 33. May I read it, my lord? While it is true that justifiability of the charges at the stage of initiating a disciplinary proceeding cannot possibly be delved into by any court pending inquiry, but it is equally well settled that in the event there is an element of malice or malafide motive involved in the matter of issue of a charge sheet, or the authority concerned is so biased that the inquiry would be to a mere farcical show, and the conclusions are well known, then in that event, law courts are otherwise justified in interfering at the earliest stage so as to avoid the harassment and humiliation of a public official. It is not a question of shielding any misdeed that the court would be anxious to do. It is the due process of law which should permeate in the society, and in the event of there being any affectation of such process of law that law courts ought to rise up to the occasion, and the High Court, in the contextual facts, have delved into the issue on that score. And at para 38, the Honorable Supreme Court has upheld it. Para 38. Now here, my lord, the allegation is of 2021, purported allegation, when the earlier writ petition was going on. In the writ petition, they filed their counter affidavit, nothing mentioned about the allegation. Now in the year 2025, when compliance of the order is required, they have issued the charge sheet, they have examined the complainant, and the complainant is so said that I have said nothing. No complaint.
Just a minute.
Yes. Is 3.3.
Where is the charge sheet? Let us see.
Yes.
Page number.
But you will kindly come to page number 73 of the writ petition. One, while working as the assistant professor of oncology, Guwahati Medical College and letters to State Cancer Institute, GMC, a complaint was received to the superintendent of State Cancer Institute, GMC, while letter dated 6/10/2021. Also, will kindly note the date. And the charge sheet is issued on 24/4/2025, so almost after 4 years. Based on multiple sources, including a written complaint. Other sources are anonymous, only a retail complaint from an attendant that you were involved in a professional malpractice. Specifically, you were found to be diverting cancer patients to private hospitals and diagnostic laboratories for treatment, and investigations that were available at State Cancer Institute, thereby violating established laws. So this is the main allegation. So she will kindly turn to page 77, that is the written complaint that is mentioned therein. Page 77 is the written complaint that is mentioned therein. Lordship will kindly mark the date 6/10/2021. And the complainant is Gangaram Chetri, down below left hand side. We visited the SCI today for treatment of my father, Sri Khemraj Chetri. We consulted in room number so and so with first lady doctor saw the patient, then male doctor saw the patient, and he advised to get the investigation in Arya Wellness, stating that the investigation in SCI will take time. So since we have financial issues, it is difficult to test outside. The vernacular copy is, my lord, at next page. Now the interesting report, my lord, at page 78. 10th of February 2025. So nothing was done for more than 4 years. In the meantime, my lord, this honorable court directed for my promotion. There also they did not mention about this complaint. Now this is an interesting matter. At page 79, so she will kindly turn to page 79. Both the petitioner and the complainant were called by that committee, and the penultimate para lordship will peruse, penultimate para. During the hearing, both the complainant and the doctor denied that the doctor had advised the attendant to get investigation done. So, my lord, the complainant himself denies that no such allegation was there. However, the inquiry committee on its own volition now goes to add on, my lord, allegations against the petitioner which has been added to the charge sheet. A clear case of an attempt is being made to overreach the direction of this honorable court contained in 16/5/2024 order, my lord, wherein this honorable court stops short of imposing cost upon the state respondents.
Now, what is this document, page 79?
Page 79 is the report, that charge at the third charge, my lord, at page 73, the charge sheet, third charge, my lord. As per the
This is a report submitted by some in-house committee.
yes. And it is mentioned in the charge sheet, my lord. Page 73 is the charge sheet. Serial number 3, kindly lordship will see. It is relied on this report, the charge sheet has been issued. Wherein the complainant says, no, I have no such complaint. And still, they, my lord, on their own volition now goes on to say that I have issued some branded medicine, this and that, and the charge sheet has been issued. Just to stall the process of promotion as directed by this honorable court. And this be sustained, my lord. That too after 4 years. And while the earlier round of litigation was going on, nothing, my lord. They filed their affidavit, no mention. That was disposed of on 16/5/2024. So on 2021, the litigation was pending.
So this report is not in your favor.
Yeah.
Come to page 80 and read.
Yes, ma'am. It's not in my favor. That's why I challenged it, my lord.
This report you are challenging.
Charge sheet, report, everything I challenged in the petition. My lord, an inquiry committee was held because as per them, in the year 2021, some attendant lodged a complaint that I have diverted them to a private diagnostic center. That complainant was called for personal hearing on 10th of February 2025. I was also called. He came and said, no, this is wrong. Their matter ought to have stopped there, but the inquiry committee on its own volition goes on to say this and that against me. Based on this report, the charge sheet has been issued. My lord, there is a definite purpose in issuing the charge sheet because on 16/5/2024, pursuant to a decade-long litigation, this honorable court directed that the petitioner should be promoted to the post of Associate Professor Oncology. They don't do so. First, they transfer me outside my cadre from oncology.
No, Mr. I have understood. You see, you are saying all this is our afterthought.
Yes.
To defy.
But
what if it is true? What, see, if you want to, you are asking for a preemptive order. You are asking that don't allow them to even go ahead with these allegations. That is the order you are asking, right?
Because what was the...
You listen, it will help
Yes,
you.
yes.
You are saying these are all absolute rubbish. And why? Because I am saying it is rubbish. So don't look into it. But they are saying that you are guilty of diverting patients
Where
to...
is the occasion to... No, diversion, yes. That the complainant has in-person come and give a statement, no. And that's why this finding, my lord, the complainant denied. So what remains, my lord?
No. You see, there is a finding that the superintendent of SCI also informed that professional man so-and-so was noticed by the authority from different sources like so-and-so.
Anonymous, my lord.
Superintendent of SCI.
Exactly. Superintendent of SCI relying on some anonymous. Where is that?
But is he a party here?
Yes.
Is he a party?
Yes. Only the written complaint written by Gangaram Sethi, that is only substantial. Rest are all anonymous, my lord. All assumption and presumption. What are the sources? In the charge sheet also they say sources, multiple sources. Can that be an allegation? It's a vague allegation. Right?
What charge sheet put?
In the charge sheet,
Huh.
they just copy paste the same. They say you have from multiple sources it has come to. What? Which sources, my lord? How will I rebut that? Only the written complaint issued by Gangaram Chetri is substantial. Rest all are anonymous, my lord. And this, the purpose for constituting the committee was to see whether I have diverted some patient or not. The moment the complainant says no, matter ought to have ended there. However, that goes on to add on, my lord, which was not the subject matter even of the inquiry committee. I humbly pray Lordship will look into the facts of the case into its entirety, my lord. A decade-long litigation comes into my favor regarding my.
What is the litigation which has come to you in your
Yes,
favor?
Lordship, that order I have annexed.
Hmm.
Lordship will kindly come to
Yes.
page number. The order starts at page 55.
Page 55.
Annexure 4 of the petition.
Hmm.
My lord, what happened? I was recruited through APSC to the post of Registrar Oncology in the year 2009. Because in the year 2008, the Guwahati Medical College Hospital, the Cancer Institute was introduced. And accordingly, my lord, many posts like Registrar, Assistant Professor, Associate Professor, Professor were required to be filled up. So it was held through APSC. I topped the merit list in the post of Registrar Oncology. And my lord, I was promoted to the next post, that is Assistant Professor Oncology in the year 2011. However, when I became eligible for Associate Professor Oncology in the year 2014, I was illegally deprived. So in the year 2014, I filed a petition, which was allowed in 2016, and the authorities were directed to hold a review DPC. Now, my lord, while holding the review DPC, they tried to tinker with my earlier promotion, which was also not the subject matter of the review DPC. Again, in the year 2018, I have to come, and this petition was eventually heard by this order at page 55. Operative portion lordship will come at para 25 and 26 at page 67.
1 minute.
Yes.
So petitioner is presently serving as?
Assistant Professor Oncology, though on 16/5/2024, the Honorable Court has directed me to promote as Associate Professor with retrospective effect from 2014. And the Honorable Court stopped short of imposing cost upon the state respondent. Lordship will kindly produce para 26 of that order at page 67. Para 26 and para 27. Page 67. Since 2014, I have been fighting.
No, you want to show which page?
Page 67.
Yes. That's the learned single judge's order.
Yes.
There is a division bench order also.
Yes.
What is that order? Where is it?
Oh, my lord, in the earlier round of litigation, when this Honorable Court directed for review DPC, it said that the review DPC will not be with retrospective effect. To that limited point, I went to the division bench. Division bench said if the review DPC held, then it should be with retrospective effect. Yes, the division bench order, Lordship will find that page 48. There were two learned signatories order. This was the first where review petition was directed. Pursuant to that, this writ appeal was preferred by me regarding only retrospective effect. The operative portion, Lordship will find at page 54 of the division bench order, page 54, para 11. Page 54, para 11.
Yes, Mr. Gogoi, there is an order passed by this court in another proceeding regarding his transfer or shifting to.
Yes, yes.
That is still pending.
That is pending, my lord. In
There
fact,
is
that
a-
has been stayed. It is pending.
It is pending. What is the case number? Do you have?
WPC 1084 of 2025.
Yes.
WPC 10?
84 of 2025.
It is coming up on Wednesday, I suppose. When is it? This Wednesday, man.
It
The
is fixed
transfer
for,
order is coming up, my lord.
for motion. It is fixed for motion.
No, the
Notice
admission,
has been issued.
admission, my lord. We have filed the affidavit.
All right. Now, you see, he is saying that this charge sheet is a mala fide exercise. It may be wrong. It may be right. We don't know. But some inquiry will be required here because there are a series of litigations. So would you like to file an affidavit?
Otherwise, yes, but my lord, whatever plea the petitioner has taken, my lord, before his honorable court for challenging this particular show cause notice, that my lord, he can take, my lord, while submitting the reply, my lord. Lordship will see the statement of allegation. There are certain documents we have relied upon, page, my lord, 75. In fact, they are official witnesses based upon whom, my lord, the charges have been framed. He will get every opportunity to, my lord, cross-examine them.
Right.
pass
Perhaps
them.
that would have been the right course. But then
Yes.
Mr. Patwari wants to test it. If it goes against him, then he is doomed. He has
Yes, that's
taken a
why I'm
big
saying,
risk.
my lord, there's no bar, my lord. Tomorrow, my lord, if any order is passed against him, say arbitrarily. We follow, my lord, arbitrarily. He can always come, my lord, before his honorable court challenging the same.
No, that's right. See, Mr. Patwari, this court will never give an opinion whether it is mala fide or not.
Yeah.
So that means it's going in a particular way. And if it goes in a particular way, the whole advantage will be lost. Your
my
client
lord,
is facing a
when
big
we
risk.
will hear the matter and take the entire facts into entirety, everything will be clear, my lord. It cannot be. And Lordship knows the law on anonymous.
But he is taking too
Anonymous.
personally, my lord. The issue is, my lord, regarding.
Everything will be stalled. Even the promotion will be stalled.
Yes, my lord.
Nothing
Lordship
can
will
go.
see, my lord. In fact, the promotion.
The whole matter is,
Petition not given.
so it will not be given.
Contempt petition is finding. After contempt, now these things have come up, my lord.
If the court examines whether, see, Mr. Patwari, you must understand as a lawyer, you are saying the charge sheet is mala fide.
Yes.
I don't even see 2% chance of court giving a finding in your favor. Then that means it is going to go against you. If it goes against you, your road is blocked for the future. But after you give your reply, this is not our job to give legal advice. If you give your advice and then they make a mistake, then you will have something on record to show that, see, this is the now you cannot even establish the mala fide. Your only argument is the person who complained in 2021, he said that I did not make the mistake. But there are other angles also which the court will never go into. Therefore, think rationally. You can insist and I'll pass an order in 3 days' time. But I'm giving you a chance to reflect.
No, my lord.
The court can never hold that this is out of mala fide today. Never. That's the law.
No, my lord, the Honorable Supreme Court has said so.
Then Argo, I'll decide it today. Final hearing.
Lordship will tag with the other matter also.
No, that
the
thing
entire
cannot
thing should be
continue, my lord.
for your Lordship. WBC 1084.
How the transfer order, my lord, that has been put to challenge in the other cases connected to a department.
Let him, yes. What do you want?
My lord, Lordship will kindly see. The allegation is of 2021 when the earlier.
It can be of 2011 also.
No, it can't be. The Honorable Supreme Court says.
Then I won't be able to take this matter.
Delay is of, delay is also an important
Right,
factor
sir.
here.
These arguments, it can't be of, how can you say it can't
Because
be?
Supreme Court says so.
Sorry, there is no such law.
My
These
lord-
are all on facts of the case.
Yes, sir.
These are all facts of the case.
Facts of the case.
How will we know the facts? How will you know the facts? There is a charge sheet. You submit your reply. After that, if you find that they are not acting bona fide, that will be the first opportunity for you to come to the court.
I would have happily submitted the inquiry, submitted my reply, had it not been to thwart the process of a judicial order. 2014, kindly have some, 2014, I have been litigating. In 2024, I get a favorable order. Now suddenly, all these things comes up and these things were not taken up before the order.
Mr. Patwari will grant a stay till Friday. But if the court rules against you, your road is blocked forever.
Yes, my lord, I will try to satisfy your lordship.
Friday will decide it
Yes.
finally. You file an affidavit.
And the entire, since there are multiple litigation, everything should be before your lordship. That is my humble prayer, my lord.
Yeah, my lord, if the particular, my lord, so
Lord,
whatever
this-
evidence we
everything.
have, shall we place it before his honorable court in a way? of an
No, he is
affidavit?
insisting that will be
That's the
prejudicial
full
to
issue, my
him.
lord. How can we, my lord, place it before his
That's
honorable
the
court?
problem.
Supposing it goes against him, then, my lord, same will be used against him, my lord. Can we place it before this court, my lord? Even by an
If
affidavit.
he is not ready to understand this,
Then, my lord, that stay part I am
I
saying.
think Mr. Patwari is being a little emotional in this matter. These are all tactical,
Yes, my lord.
tactical battles, Mr. Patwari. You must
That is
understand.
very true, but Supreme Court says there are at least 8 grounds, my lord, in which a charge sheet can be interfered with in the initial stage, my lord. Out of this is, my lord, bona fide.
Wednesday, final hearing.
My lord, day after tomorrow.
Yeah, day after tomorrow. But you are taking a big risk, Mr. Patwari. I must tell you that. On the request of Mr. J. Patwari, learned counsel for the petitioner, let this matter be listed again day after tomorrow as a fixed item. Mr. B. Gogoi, learned standing counsel, learned additional AG Assam Health Department, may file preliminary affidavit bringing the stand of the department on record on or before the next date fixed. Wednesday? we take it?
Your lordship,
Yes.
Obligation.
Sir, I'm seeking a week more to file my additional affidavit as was directed in the last order, my lord. Actually, the petitioner, he left to join the place of his posting. And he either have to send the affidavit there or he has to come back on resolution.
Achha, so he is joining.
Because my lord, he was issued a movement order, there was no stay. It would be a discipline proceeding against him in the case. His wife is
Then
not.
why don't we issue notice? You file your affidavit and we'll just observe that he is joining in the place of posting will be without prejudice to his rights and contentions in the rate petition. Right? Let him file his affidavit. And you file your reply and it will be decided on merit. Mr. R. Majumdar and counsel for the rate petitioner submits that the affidavit on behalf of the petitioner as permitted by order dated 11/6/2025 passed by this court would not be brought on record since the petitioner has already left Guwahati to join in his new place of posting pursuant to the impugned order of transfer. Mr. Majumdar, however, seeks protection of the interest of his client as the interest of this client so as to ensure that the writ petition does not become infructuous in the meantime. Mr. B. Chakravarti, learned CGC, is present on behalf of the respondent. Taking note of the submission of learned counsel for the petitioner, this court is of the opinion that the matter will require further examination. As such, issue notice of motion returnable on. We'll give it on 30th of July. Mr. Majumdar, 30th of July. 2025. Since Mr. Chakraborty has appeared and accepted notice for all the respondents, no formal notice is required to be sent in this case. Extra copies of the writ petition requisite in numbers be furnished to the learned department counsel so as to enable them to obtain, instruction. In the meantime, parties to exchange pleadings. It is made clear that the joining of the petitioner in his new place of posting will be without prejudice to his rights and contentions in this writ petition. Stop. So we'll.
Bless you.
That is regarding reimbursement of it.
Lordship, here I had raised an objection because the challenge was made after 10 years after the issuance of the order of recovery. So I checked up the judgments passed. There appears to be two streams of judicial precedence, Your Lordship. The one stream says, Your Lordship, though delay in laches is a factor, but when examining such a case, a court has to definitely, a high court has to definitely consider a breach of fundamental rights, a continuing cause of action, whether any third-party rights have been created, etc., etc., and whether the delay was intentional or was it deliberate. But there is a second stream, Your Lordship, which says that even in cases where a petitioner has a justifiable cause of action, and even if there is a breach of fundamental rights, delay, laches, and acquiescence, Your Lordship, will be fatal. Because a person may have a right. Delay and laches per se will not extinguish the right, but it will extinguish the right to have that right enforced, Your Lordship. And
if it gives rise to a parallel claim, then only, not otherwise.
Lordship?
If it gives rise to a parallel claim of someone else,
yes,
then only it will extinguish, not otherwise.
My understanding is, Your Lordship, when the person by his own conduct, the principle of acquiescence, Your Lordship, explicit or implicit conduct has given away his right to have that right enforced. He has not availed any measure for enforcing that right, Your Lordship, but then perhaps a court may, Your Lordship, refuse to exercise, Your Lordship, its equity jurisdiction. But of course, that will depend on the facts and circumstances of the case, Your Lordship. Though in the constitutional bench of Hailal Bhai, Your Lordship, the Honorable Apex Court had held that where there is only a claim for recovery of monies due, because here that the recovery was illegal, that has already been laid down by the Honorable Apex Court in Traffic Masi. So this petition is only for recovery of the money which was illegally recovered. So the constitutional bench has held, Your Lordship, that where there is the primary claim is for recovery of monies due, then the period prescribed by the Limitation Act, Your Lordship, if it is beyond that period, then such delay would have to be held to be unreasonable.
Well, issue notice, not
very
expressing any other opinion. Let's take down heard Miss M. Das, Learned Counsel for the M. Das. Then your Miss?
The Angana.
Huh?
The Angana. Oslit, I mean. Thank you.
D. Angana. D. Angana, Learned Counsel for the writ petitioner. Whereas the statements made in the writ petition being aggrieved by the memo dated 17/3/2015, by means of which an amount of rupees 1,97,832 had been deducted from the pensionary dues of the petitioner on the ground of overdrawal. The instant writ petition has been filed. Mr. K.P. Pathak, Learned Standing Counsel, APDCL, appearing for the respondents, has questioned the maintainability of the writ petition on the ground of delay in laches in approaching, on the part of the petitioner in approaching this court. The petitioner's, the Learned Standing Counsel has, however, prayed for some time to seek, to complete his instruction and file affidavit. Prayer is allowed. Issue notice of motion returnable in 8 weeks. Since Mr. You have for all the respondents, Pathak has appeared, then accepted notice for all the respondents, no formal notice. Extra copy of the writ petition. The question of maintainability of the writ petition is kept open and shall be considered at the stage of admission hearing. So it is only when there is it stands extinguished if it is a parallel right.
Yes.
But there will be another angle to this case which will be, it's a money claim.
It is a money claim.
So if it is not within 3 years,
yes,
then even pensionary and other dues in case of money claim, there are judgments of Supreme Court. You also check out. Have you seen those judgments? You have seen.
No, Lord.
Your claim is barred. It's more than 3 years. So it is not delay in laches, but limitations that will play a crucial role. Check it out. Yes.
Okay.
Hello, I have provided a copy of the order, Your Lordship. Your Lordship, before your Lordship passes an order, a similar order.
Can you speak a little louder?
Yes, my Lord. Before your Lordship passes an order, I need to make a short submission, my Lord.
So what has happened after passing of that order dated 25/3/2025?
Hmm.
Your Lordship, the authorities, they have issued a termination notice against me. Although I was not a party in that case, they have issued termination notice against me. I have a copy of the termination notice, Your Lordship. So now they have put this notice whereby my employment will be terminated with effect from 29/6/2025. So there is very limited time, Your Lordship. And if Your Lordship allows me to satisfy Your Lordship regarding the whether the Deputy Commissioner has the power to issue such a notice.
Just a minute.
Yes, Your Lordship.
So 60 days notice has been given to
Yes,
you.
yes, Your Lordship, already given, although there was no order passed against me.
No, that is fine, but this is a general observation.
Yes, fine. But another thing, my lord,
The
the
60 days will expire when?
on 29/6.
So you are on contractual employment.
Yes, at temporary contractual employment.
Hmm.
And we are sought to be removed, replaced by another set of temporary contractual employment. That is why the advertisement that is there, we have included that. Yeah. And the respondent number 4, the Lordship, the District Commissioner Borpeta does not have any right to issue such a notice, such an advertisement. Your Lordship, if your Lordship produces the guidelines, Your Lordship, it will be very
But
clear.
you are in contractual employment.
Yes.
Your terms of appointment will be governed by the contract.
Yes, Your Lordship.
Contract permits them to terminate with 60 days notice.
The contract actually doesn't exactly says that. Your
Where is
Lordship.
the
Your
relevant
Lordship will
provision?
find my appointment letter in page number
Hmm.
Page number 75 of my additional affidavit, Your Lordship.
Page number 75.
75. Operative portion is in page number 76. Sir. Your Lordship, it says, point number 7.
Hmm.
You will serve a notice period of 1 month for leaving your appointment with the organization. If you fail to give 1 month notice, you will be.
That is when you want to leave.
I want to leave, Your Lord.
Yes.
Otherwise, there is no such conditions in the appointment letter that provides that the authorities can remove me.
So it can be terminated with 1 month's notice.
1 month's notice in my case, otherwise in their cases, it was 2 months notice.
But here they have given you 2
The
months
2 months
notice.
they have
Then-
given me, but there was no such condition in my appointment letter. And another
That's the
thing-
difficulty. These are contractual appointments.
Yes, my lord, I understand that. My lord, if your lordship kindly looks into the this thing, guidelines, my lord, Commission Shakti, on the basis of which they have issued this entire
Page
advertisement.
number?
Page number, this is another copy. I have the entire.
No, you see, you first have to tell me what is the point you're canvassing? Your
Actually-
client is in contractual agreement,
Yes.
engagement.
Yes,
Contract says it can be terminated,
yes.
but with notice, 1 month's notice.
Terminated.
They have given you 2 months notice. So once you have signed the contract, the parties to the contract agreement can take action within the realm of the contract.
But the respondent number 4, he is not a party to the contract. He is a stranger to the
No,
entire
who has signed the contract? With whom?
contract, your lordship. It was with the NGO that was implementing the entire scheme.
NGO is under some government
Yes,
department.
they were under the child and women and child development department. They were operating under the child and
So the
women and
deputy
child.
commissioner of the district is ultimately the nodal authority.
Nodal authority, not exactly, Your Lordship. In this case, Your Lordship, there are certain guidelines. So in 2022, they have formulated a guideline called the Mission Shakti guideline. As per that guideline, there is a institutional arrangement of center, state, and district level. So in that portion of the guidelines, it is clearly stated that in district level, overall implementation of the scheme of district at district level will be done by a committee headed by the district magistrate, district collector. It will be headed by the district magistrate or collector. In this case, perhaps the deputy commissioner.
So you are saying that
There is no committee. The committee has not.
no. Are you challenging that notice?
Which notice?
Notice 2 months.
The notice, yeah, we will challenge it in a subsequent petition.
In this writ petition, you have not
No, I'm not
challenged.
challenging. I'm challenging the advertisement, and there are also many.
The advertisement, they are processing it.
They are processing. As per your lordship earlier order.
Yes, there is already order. What order you want me to pass here?
I was just apprising your lordship regarding what has happened. And another thing, your lordship.
No, another thing will come. What order are you expecting here?
I'm just apprising your lordship.
You're just saying, but you don't really
No,
want
I
an
want,
order.
if your lordship can decide the matter today itself, because the time is very short.
No, it's not possible. This advertisement was issued long time back.
Yes, your lord.
Then you suddenly come and say, decide it today. How is it possible?
No, because due to some.
They will have to file affidavit.
Well, they have been taking time in that other matter.
Are you also there in those writ petitions?
Sorry.
Are you appearing in those writ petitions?
Yes.
Yeah, you are appearing. So at the moment, I'll have these matters tagged together. And you file your petition challenging the.
Yes, that's it.
You take down, hard Mr.
Das.
Das Learned Council, preparing for the writ petitioner. Here is the statement made in the writ petition. The petitioner, who was earlier appointed as a Sakhi one-stop center in Borpeta district, has approached this court, being aggrieved by the advertisement notice dated 4/3/2025, is it? Published by the District Commissioner Borpeta, inviting applications for fresh appointment of Sakhi. First up, Mr. Das submits that similar writ petitions are pending before this court, wherein interim orders or appointments are operating. First up, he has produced a copy of the order dated 25/3/2025, passed by this court in WPC number 1665 of 2025. Ms. A. Talukdar, Learned G. Assam, appearing for the official respondents, on the other hand, submits that there is no stay of processing of the advertisement, but the respondents are only required to serve 2 months advance notice upon the contractual employees, and the said requirement has been followed in case of the petitioner as well. First up, Mr. Das, Learned Counsel for the petitioner, has also accepted the fact that on 29/4/2025, a notice was served upon his client giving 60 days period to giving 60 days notice of termination of the contract. First of all, in view of the above, issue notice of motion returnable in 4 weeks, since Ms. Talukdar has appeared and accepted notice for all the respondents.
For 2 to 6, Lordship.
And who is for 1? Achha, for 2 to any CGC here? Mr. K. Gogol and CGC for respondent number 1, and Ms. Talukdar and G. Assam for respondent numbers 2 to 6, no formal notice is required to be sent in this case. Extra copy of the writ petition. Requisite in numbers be furnished to the learning department council so as to enable them to obtain instruction. On the prayer of entry, it is hereby provided that the interim order dated 25/3/2025 operating in WPC number 1665/2025 shall operate in the present case as well. Office to list the matter along with WPC number 16650/2025.
Till 29/6 they are.
Yes, you can't help it. They'll terminate your service. You can't help it. You have accepted it. Either you have to make out a case, otherwise can't help it. So difficult. You can't help it. These contractual services can be terminated. We can only examine the procedure adopted, whether they are doing it in accordance with principles of natural justice, whether there is any malafide, any arbitrary.
In this case, Your Lordship, the authority who has issued the advertisement.
Why don't you participate in the selection process?
Process, although we can, but
You should have participated without prejudice to your rights. You have to make out a case. No? You can't just say that I don't want to go, I don't want that. This kind of things can't be accepted by the court. You have to come up with a legally sustainable plea. Your client participated in the selection process.
No, madam.
Why? Contractual employees, only the terms of the contract will govern.
But replacing one set of temporary workers with another.
Contractual, it is permissible.
Contractual.
Ad hoc employees by the state, not permissible. Contractual, yes. Contract, the meaning is that they'll keep on replacing. That's why it is contractual.
Then we will. Put that. Authorities.
You speak a little louder.
Authorities, whether they do have an authority to file that, to issue that advertisement, that is also.
That they will file. If they don't have, then it will be quashed. But your 2 months after that, the service will be over. Then you have to come up with a fresh plea. Any order passed which is not in accordance with legal principles will not be implemented. Yes, next matter, please. My sympathies are there with your client, but we are bound to discharge our duty in accordance with law. Yes.
There is an order in WPC number 3/2025 to take this matter along with this WPC lordship, which is fixed on 22nd July.
These are part of, I'll release it from part of. Only
This is part. Others are tag on.
No, Partha, I'm not going to be able to hear this case. You know the reason. So it's not possible. I'm just waiting for an order any day. Tomorrow or day after, any day it might come. So now it is not possible to complete hearing and deliver judgments. Learned counsel for the parties are present. Considering the fact that you write due to operational reasons, bracket, transfer of the presiding judge, it will not be possible to hear and deliver judgment in these cases. Therefore, these matters shall not be treated as parted before this court henceforth. Please take on.
December 20 and 27, there is a hearing order.
Let these matters be listed before appropriate bench again after 2 weeks as fixed items. Interim orders operating in these cases shall continue till the next listing. Till the next date, it will continue. Huh? You tell me when you want it.
22nd, because the connected matter is fixed on.
Then list on 22nd of June, huh? Not after 2 weeks. 22nd of July, 22nd of July.
There's a
22nd July.
It was it, my lord.
List these cases on 27th of June. Okay? Nothing will be happening that day.
Lordship,
Last day of the, why
Lordship,
are you unnecessarily making
Lordship,
requests?
all the matters are connected matter, Lordship. So 20.
You make that request on 27th, yes. 27th, when it comes, obviously the matters will not be heard on 27th. It is the last working day. But he wants it, so I have given it. That day you make a mention. See, once the learned counsel stop responding to the court's query in a rational manner, what option do we have? 28th onwards is summer vacation, 22nd is the earliest date possible. He wants it on 27th, so what to do? You make a mention on 27th. Yes, all right.